contracting party ought to be very careful when terminating a contract early. Termination is often not clear-cut, and more than often it is disputed. A party may want to exit a contract as the other party has committed a breach, say for example, a refusal to perform their obligations or the performance is not to a standard expected. It may also be because it's no longer commercially viable, the relationship has broken down, or the conduct of the other party is worrying from a reputation management point of view. A well-drafted contract will include a provision for how the parties can exit the contract. These will usually include termination for cause, such as the insolvency of a party or breach of contract, commonly upon a material breach. There may also be an ability to terminate for convenience by giving written notice. In the instance where you can terminate by notice, the notice provisions in the contract should be followed to the letter. As well as what is in any written contract, or in the event that there is no written contract, there is a common law right to terminate for repudiatory breach. A repudiatory breach will occur when a party commits a breach that is so serious that it goes to the root of the contract. If a party has committed a repudiatory breach, the innocent party has two choices. It can either accept the breach and terminate the contract. The remedy is then damages flowing from the breach, or it can affirm the contract. That is, insist that the contract continues to run. If the parties don't do this voluntarily, then you can seek an order for specific performance, and if urgent, an interim injunction. You may want to affirm the contract perhaps in circumstances where it would be more profitable for it to run as opposed to terminate. You should also act quickly after the breach, and therefore the right to terminate has occurred. The longer you leave it, the harder it is to prove that the other party's conduct is a repudiation, and you can lose the right to terminate. Any communications surrounding termination, such as the termination notice, should be very clear and unequivocal and leave no room for doubt as to the intention, as well as stating the grounds for termination. A termination notice cannot be revoked, nor can you change the reason for terminating at a later date. Careful consideration and advice should be sought on whether a repudiatory breach has occurred. This will turn on the facts of each case. It is important to note that a party may not rely on its own breach to terminate a contract. In order to rely on contractual or common law provisions, it must be the innocent party. The consequences of making a wrong decision on termination can be substantial. If you terminate, you may either lose out on future contractual payments and profits. It may be more profitable to keep the contract alive. You may be liable for damages. Should you terminate a contract on the basis of what you say is a repudiatory breach and it's later not considered to be so, or you're terminating on a contractual right that does not exist, you will have wrongfully terminated the contract. This is a repudiation in itself, giving rise to a claim for damages against you. You may also lose another termination right. Often there are concurrent rights at common law and contract. If you elect to exercise the wrong one, you may lose the right that may have actually been effective or had a different, perhaps greater, calculation for damages. Sometimes there is not an obvious breach and the position becomes unworkable or commercially unviable, and there's not a mechanism for terminating the contract, nor can you point to a breach sufficiently serious enough so that the contract can come to an end. In such cases, it's always open to the parties to negotiate a new position. Again, care must be taken in these negotiations so that you're not indicating that you will breach the contract in the future. This may amount to an anticipatory repudiatory breach. It's usually advisable to have any such conversations with the other party on a without prejudice basis. What is clear is that each case will turn on its own facts, and there may be a multitude of factors at play. So it's incredibly important to take advice when considering your termination rights.